Hello, my name is Untitled. Welcome to another lecture in PL 445.
My name is
Evidence 1.
Welcome to another lecture
examine
in
the
PL
topic of
445. Evidence
And
1.
at the end of the lecture,
Today we are
we
going
will
to
appreciate
examine
the
the
nature
topic
of
admission.
admission and the importance of
And
admission.
at the end of the
We
lecture,
will also
you will
understand the
appreciate the
different types
nature
of
of
admission,
admission
such
and
as
the importance of
informal and
admission.
formal admission.
You will also
We will also
understand the different
understand
types
the
of admission,
consequences of
such as
admission in
informal and
evidence.
formal admission.
I believe that
You will also
you will enjoy
understand the
today's
consequences
lecture.
of
Thank you.
admission in evidence. I believe that you will enjoy today's lecture. Thank you.
Once again, you are welcome to today's lecture. Untitled is my name. At the end of this lecture, you should be able to define the concept of admission, discuss different types of admission, and explain the reason for admission. Admission is defined in section 20 of the Evidence Act 2011. It says an admission is a statement, oral or documentary, or conduct which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and in the circumstances mentioned in this act. So admission can be a statement, it can be oral, it can be documentary, it can also be by conduct. Who are the people who can make admissions? Section 21 subsection 1 says that statement made by a party to the proceeding or by an agent to any such party whom the court regards in the circumstances of the case is expressly or impliedly authorized by him to make them are admissions. So admissions can be made by parties to the proceedings. It can be made by their agents. If you look at subsection 2 of section 21 says statement made by parties to suits suing or sued in a representative character are not admissions unless they were made while the party making them held that character. Now subsection 3 provides statement made by persons who have any proprietary or pecuniary interest in the subject matter of the proceeding and who made the statements in their character of persons so interested. So if somebody who has a proprietary interest or a pecuniary interest in respect of the subject matter of the proceeding now makes a statement, then that statement becomes an admission, so long as they made such statements at the time where they held that position, where they have that character of having pecuniary or proprietary interest in respect of that particular property. Other persons who can make such admissions can be found in section 22 and 23 of the Evidence Act. Now if you look at the case of Ogunnaike versus Ojayemi, the court said an admission is any statement, oral or written, express or implied, which is made by a party to a civil proceeding and which statement is adverse to his case. Once admissions may be formal and they may be informal. Admission was made by a party, it relieves the other of the duty of proving the admitted fact, because this is because he who asserts a particular fact or allegation is bound to prove that. But once there's an admission by the other party, then there's no need, there's no burden anymore on that other party to prove that which has been admitted. Now if we look at the case of Odofia versus Opareke, Odofia versus Afia, it was held that facts alleged positively in a pleading must be taken as admission by the party alleging them if such facts are admitted by the opposite party in his pleading. So it simply means that once a party makes a formal makes an allegation in his pleading, and the other party admits it. So the person who made those allegations cannot then resile from those facts which he has alleged, which the other party has admitted. Now, in the next slide, you will be required to provide answer to the question in that slide. Admission is an exception to the principle of he who asserts proves that which he asserts. Now let's look at formal admissions. Let us look at formal admissions. We say formal admissions are admissions that are made in the pleadings or in the course of proceedings. So if an individual makes an admission in the course of proceedings or in the pleadings, then that is regarded as formal admission. I've already made reference to Odofia versus Afia. So admissions can be made in the pleadings. Apart from that, admissions can also be made in the course of pleadings. Sorry, in the course of trial. During the course of trial, admissions can be made. If you look at the case of Mwiziwike versus Eneyoke, in that particular case, the judge was on a visit to a Lagos Inquo, and both parties made admissions during that process, and the court, relying on those admissions, gave judgment. Now one of the parties then appealed and said that they ought to have been recalled and for them to make such statement in open court. And the court said no, that the court did not cease to be a court when it was on a visit to a locus in quo. So once an oral admission is made in the course of proceedings, it is then regarded as a formal admission. Admission may also be made by implication. This may be as a result of failure to deny an averment contained in a pleading. So if there's an averment in a pleading and a party fails to deny such an averment that is contained in a pleading, then it is regarded that an admission has been made. You may have to look at the case of Economind versus Tomopoulos, 1956, 1, Federal Supreme Court at 7. So once an allegation, so it is incumbent on a party to a proceeding that once an allegation, a material allegation is made in a pleading, in respect of a matter in dispute, in respect of a fact in issue, the party is bound to deny such allegation if he intends to deny same. Otherwise, it will be deemed to be an admission. Now, formal admissions operate like estopel. It prevents a party from denying the existence of the fact which he had earlier admitted. So if a party makes an admission in court, whether in the pleadings or whether in oral testimony in court, he is precluded, he is prevented from denying that which he has already admitted. So in that regard, formal admissions operate as estopel. If you look at the case of Ajide versus Kelani, now Justice Chukwudufo Puta of blessed memory did a graphic illustration of how formal admissions operate. He said a party should be consistent in stating his case and consistent in proving it. He will not be allowed to take one stand in his pleading, then turn somersault during the trial, then assume of nonchalant attitude in the court of appeal, only to revert to his case as pleaded in the Supreme Court. Justice is much more than a game of hide and seek. It is an attempt, and our human imperfections notwithstanding, to discover the truth. Justice will never decree anything in favor of so slippery a customer as the present defendant appellant. What Justice Chukwudifo Puta is saying there is that you have to be consistent, and that's what admissions is all about. So when you make admissions, you are not permitted to resile from such admissions. Otherwise, there will be no consistency in your work, in your case. So once you plead a particular fact, you ought to be consistent with it. Once you plead a particular fact in your pleadings, you ought to be consistent with it during your trial. If the matter goes to Court of Appeal, you ought to be consistent, and if it goes to the Supreme Court, you ought to be consistent with respect of the allegations which you have made in your pleadings. In that way, it is easier for the court to determine where the truth of the matter lies. So the rationale for formal admission is consistency of the parties' case. Now let us look at admission during negotiations. It is the policy of the law to ensure that parties settle their matters amicably, and therefore the law encourages amicable resolution of matters between parties. And when parties resolve matters within themselves amicably, they usually make admissions which ordinarily they wouldn't have made in the course of proceedings in court, because it is said that the court deals with hard law and cold facts. So parties can make admissions. They can yield to the other party. They can concede certain things to the other party through negotiations. So during such negotiation, the law does not recognize any admissions made therein. The law recognizes such admissions as being made without prejudice. So the court does not necessarily admit, or does not really admit, any admissions made in the course of proceedings, whether orally or in writing. Such admissions are said to be made without prejudice and not permitted to be tendered in court, or they are not admissible in court without the consent of both parties. Now, but it is safer when writing such letters meant for negotiation to mark them without prejudice. Nevertheless, if there's no real negotiation that is going on, and parties make such admissions, then they will be rendered admissible, because in truth and in fact there is no such admissions, there's no such negotiation that was going on in that regard. But it is always safe to mark them without prejudice. Now let's look at the case of Besala versus Stein, where it is the failure to give any direct reply beyond giving the money, beyond giving plenty money to induce her to go away, when she said to him, "You know, you always promised to marry me, and now you don't keep your words." It was held to be an admission or promise to marry. But the reverse was the case in the case of Wedman versus Walpole, where the court did not accept it as an admission when the plaintiff wrote to the defendant and the defendant failed to reply. The court did not rejected it, the failure to reply, as an admission, and the court then made a distinction between business letters and social letters or communications. And in such social communications, failure to reply was deemed not to be an admission, unlike in business communications. In the next slide, you will be required to provide an answer to the question therein. Difference between formal and informal admissions. In this lecture, we have seen admissions, the definition of admissions, formal and informal admissions. The formal admissions are those admissions that are made in open court, in pleadings, or in the course of trial, while informal admissions are those admissions that are made before the suit was pending or before the case was filed. I hope you enjoyed today's lecture. Thank you.